It feels like a week ago already. So here's what happened. Back in January, I had agreed to plead guilty to third-degree possession of a controlled substance. Now, in Minnesota, what that means is that for my purposes, it is possession of more than 10 grams, less than 25 grams of a mixture containing various controlled substances. In this case, in particular, cocaine. Now, what I actually possessed in there was cocaine, Molly, and ketamine. And the police treated it as a single mixture. It wasn't mixed up. It's kind of a misnomer, but they combined all of the powdered substances effectively, and came up with a gross weight. Now, when they initially weighed it, the weight was 26 point something grams. However, that included, because they weighed it in the field for the purposes of making a charge. They don't take it out of the package, because if they take it out of the package, they've compromised the evidence, and then it's not very useful, right? So they weigh it in the field, and they include the packaging. So these are in little gem bags about this big. Some people would, I guess, call them dime bags. Maybe is that the word? I never did much marijuana, so who knows? But these little gem bags is what they're called, if like a hobby store, and each one of those weighs like 1 to 2 grams. So if you have, and there were 3 of those baggies, because you have a baggie of cocaine, baggie of Molly, and a baggie of ketamine, and then there was what's called a cutoff bag, which is where they take like a Ziploc and they slice off the zipper part of it. And that had the bulk of the cocaine that I had. Now, people talk about how much it was. It's really, it's not that much. 19 grams is about the size of a ping pong ball, something like that. It's a lot and not a lot at the same time. Guys, the reason's pretty simple. It's like going to Costco. Like, it's a pain in the ass to get drugs, so you just buy in bulk. It's just it's funny that the way drug charges work out is because they do it by weight. This is I'm not sure of the better practical way to do this, but drug possession charges are illogical from a liberty perspective, because it is, if I took an entire ounce of cocaine and did all of it and the cops show up, there's no cocaine. There's no charge. You can be high as a motherfucker in most states. Not every state. In most states, you can be high as a motherfucker as long as you're not driving or engaging in some sort of disorderly conduct. You can do, and you could live through an ounce of cocaine, I guess, if you could try it. And you do it all, that they can't charge you with a crime at all. If you don't do the cocaine, if you don't do it and you put it on a shelf and you have over 25 grams, you get a second-degree possession charge and felony with a punishment of up to 25 years in prison. The disparity logically between those two outcomes should render drug laws completely moot until they come up with a better structure for it. The fact that it is illegal to have it sitting on a shelf, like you could buy that cocaine, it could sit on a shelf forever, and you can never intend to use it, that's illegal. Having it and using it immediately is illegal because you have it, but once it's gone, they can't prove that you have it. And they can't prove without some extra evidence that you ever had it in your possession. What they could do is find out that you're under the influence of cocaine, but possession and use are different. And that's weird. Just conceptually, the person not doing it is more guilty than the person who's doing it. So just from that alone, drug laws need a huge revamp. But anyway, it's about a ping pong ball size. And so that's in a cutoff bag. Cutoff bags weigh a little bit less than a gem bag because they don't have a Ziploc on them. So anyway, what we had was effectively, we being me, but what we had effectively is 5 to 7 ounces, or not ounces, grams of bag weight. And once they got into the lab and they weighed it again, the official weight that came back was under 20 grams. It was 19 point something. And so they had to drop the charges down from second-degree possession to third-degree possession. So that's what I pled to, third-degree possession. The child charges were unsustainable, and so were the gun charges, kind of, maybe. I mean, like, they couldn't ever actually, they didn't have a way to prove that the guns were present around cocaine. Like, they just knew that there were guns in the house and there was cocaine there. There's a presumption there that they could try and argue, but were the guns ever in use while cocaine was being consumed? Were they, like, what does present mean is an argument. So those charges got dropped. The child endangerment charges, the children were never in danger. And then the gun charges were also dropped as part of my plea agreement. So that's all done. Now, the result of that is Minnesota has a statute. And if you have a third degree or lower, well, I guess technically higher, but the third, fourth, or fifth degree possession charge, there's a statute, if you're a first-time offender, that says you may receive what's called a stay of adjudication. Now, this is a critically important part of how this works. You are not adjudicated guilty if you take this agreement. So I pled guilty. The judge records the guilty plea, but does not accept it to the court. Okay? So my guilty plea exists, but it's not actually real according to the law. Instead, you go through a probationary diversion, effectively. And there are terms of probation that are imposed upon you that can look really similar to a sentence, but they're not. Those terms of probation are something you comply with. And if you comply with them to the letter or whatever, your charges will be dismissed, as in you will never be adjudicated guilty, or I will not be adjudicated guilty. So this is important for things like voting rights and gun rights. I am not a felon. I can go vote. If I were convicted and then later had my conviction expunged, practically those can have a similar effect, but during the conviction, you cannot vote, right? Like, so that would be a different thing. I'm not able to own guns as a condition of probation, but as I will not be a convicted felon, I don't actually lose my gun rights specifically because there isn't a conviction. There isn't a felony that would trigger the loss of the gun rights. So that is what happened for me. So I have this stay of adjudication. Now, Minnesota, the probationary, the stay of adjudication period can be up to the maximum sentence, which in theory would be 20 years. But they recently changed it for a bunch of crimes, including this one, where it's up to the maximum sentence or 5 years, whichever is shorter. And so in this case, I received 5 years of probation, which is the maximum amount that can be given out for my charge. Even though in just a couple of years ago, it could have been up to 20 years of probation, which is insane. I actually think 5 years of probation is insane. Look, people can decide what they want about why I say that, but the reality is this. Until you've had a government tell you that you just can't do something for a period of time, and there's nothing you can do about that. And if you do it, like, and it's the thing that, in my case, ignore the drug, like no drugs allowed, because obviously drugs are illegal as a matter of course. But to say that I cannot drink alcohol for the next 5 years is like, that's kind of a lot. And it's kind of wild, especially because I don't have any criminal act involving alcohol at all. But that's just how Minnesota does it. If there's a substance crime, no alcohol and no substances that are not prescribed.